Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great show for you. First, let the games begin. And I'm not talking about the Olympics. I'm talking about the motions hearing in the Delphi murder case for Mr. Richard Allen. R. Kelly wants the United States Supreme Court to hear his case. Hannah Reed Gutierres wants out of jail. A drunk driver is indicted for murder. A love story or a publicity stunt, you let me know. And of course, this happens in Florida. And then our dumb criminal of the day revives the old defense of, those are not my pants, kind of. Well, let's talk about it.
All right, lawyer.
Good day, everyone. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications so that you get word of when we go live or put up new content. Now remember, it's Tuesday, so we'll be here at 6 p.m. Mountain Time. We'll do our live show, and then we'll do our Patreon show where you can call in. Who knows? Maybe we'll do a call-in just on the regular show, and we'll talk about whatever you want to talk about. But before we begin today's show, we got to make some money. So how are we going to do that? Well, hopefully you all are going to go to the link below for U.S. GoldTrust and check them out. You don't have to buy anything. All you need to do, fill in your information. They'll contact you. And if it is the right fit for you, you can check and see if you want to put some of your retirement plan into gold and precious metals. Now, why would you want to do that? Well, let's think about it. The national debt just hit $35 trillion. Who's going to pay that back, ladies and gentlemen? It's not like the U.S. dollar is worth what it used to ever since they went off the gold standard. So it's good to have some of the good stuff that you've had for years and years and years. So go to U.S. GoldTrust and check them out and see if they can reduce some of the uncertainty about the retirement plans you may have in the future. Gold value is projected to hit an all-time high in 2024, and with gold holding its value, it is a great investment. Now, there's a group of individuals that are standing by to answer any questions that you may have, walk you through the process, and see if you want to put some of your 401k into precious metals. Check it out, talk with them, think about it, do your research, see if it is the right decision for you. Check them out, U.S. GoldTrust. I have gold, ladies and gentlemen. It's a good investment. It's not going down, it's only going up. And when the United States government owes $35 trillion, well, they can either print more money and devalue all your money and make things more expensive because of inflation, or they're going to have to implement austerity programs, which means cut 50% of the United States budget. You think that's going to happen? Oh, no. So what are they going to do? They're going to print more money. All right. Let's go ahead and get to the docket today for July 30th, 2024, and let's get rolling. That's right. Let the games begin. Yes, the Delphi murder case. Now, this is not being televised. I wish it were. If I had Crime Talk 1, which I went and checked on today, we could go out there and check this out because this is going to be a circus. That's right. The hearings as it relates to Richard Allen. Now, he is scheduled for hearings the next 3 days. Now, for those who aren't familiar with it, Richard Allen is accused of killing Libby German and Abby Williams in Delphi, Indiana back in 2017. And the hearing is scheduled for 3 days, Tuesday, Wednesday, and Thursday. And it is all taking place in Carroll County Courthouse in Delphi, Indiana. Now, over the next several days, the judge will consider 6 main topics. First, Allen's safekeeping, should he stay at the Indiana Department of Corrections facility or move to a county jail right before trial so he can assist his attorneys with his defense. Psychologist statements, whether statements from the Indiana Department of Corrections psychologists can be used. Motions to suppress Mr. Allen's statements. Defense wants to suppress what he said while in custody before trial and what he said to Indiana state police officers the day that he was arrested. There's a bunch of discovery issues. Defense wants to compel some discovery from the prosecution and have the prosecution sanctioned for not turning it over already. Now, what both sides can and can't say in front of a jury without specific permission from the judge will be decided. Those are motions in limine, as well as defense requests to dismiss the case. As it relates to safekeeping issues, Richard Allen's defense team is requesting to vacate the safekeeping order, which would move Mr. Allen out of the Indiana Department of Corrections custody. The defense is requesting Allen to be housed in either the Cass County or the Tippecanoe, if I pronounce that correctly, I'm sure I failed miserably, at the county jail. In July of 2023, the judge denied the previous request to vacate the safekeeping order. At that time, though, she wrote, "It is reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury to himself." As it relates to the psychologist statements, the state is asking the judge to decide before the trial whether certain communications from Allen and the Indiana Department of Corrections psychologist can be admitted. The state said it believes some documented statements fall within an exception to the confidentiality as it relates to the doctor-patient privilege. It cites a portion of a code saying information may be an exception in the following circumstances. 1. Trials for homicide when the disclosure relates directly to the fact or immediate circumstances of said homicide. Statements are documented in the report she titled Department of Corrections Behavioral Health Suicide Observations. Now, the defense has two motions to suppress various statements. The first motion to suppress deals with statements Allen reportedly made while in pre-trial custody. The defense wants to eliminate the possibility of prison guards or other inmates testifying about what they reportedly heard Mr. Allen say. The second motion to suppress deals with statements made to the Indiana State Police just before he was arrested. Back on October 26 of 2022, Allen and his wife went to the police station in West Lafayette to pick up a vehicle that was seized earlier that month. When they got to the station, Allen had a conversation with the state trooper, Officer Jerry Holloman. The defense wants the contents of that conversation kept out of evidence and not submitted to the jury. Prosecutors object to both motions to suppress the statements, stating that they're legally permitted. They're admissions by a party opponent in this particular case. Remember when we always say anything you say can and will be used against you? People think it's just statements to the police. It's not. It's anything that you say to anyone that is relevant to the case at hand. It's an admission by a party opponent, ladies and gentlemen. It's not hearsay. As it relates to the motion to compel, the defense filed a motion to try and compel the state to turn over discovery and to do so within a timely manner. They are also asking for sanctions against the state prosecutors. Now, the defense wants the prosecution to provide a written explanation of what the defense says is a delay in providing evidence and why the prosecutor sent an email filled with false statements and misleading the defense. Now, much of the motion's detailed discovery, the defense claims, was turned over later than it should have been, and often in a way that made it difficult to determine what is what in the discovery. The defense wants 4 sanctions: for the court to tell the jurors the prosecution violated rules with the delay in turning over exculpatory evidence, permit defense to play any video that was produced late without state objection, prevent the state from rebutting evidence former Rushville Police Chief Todd Click provided on May 1st of 2023, and prevent the prosecution from using any data or information from Liberty German's phone in evidentiary presentations. There you go. Interesting sanctions indeed. You notice they're not asking for the case to be dismissed based upon those sanctions, because that is an extreme remedy that the judge would not likely grant. They're getting a little creative. Obviously, they don't want any data from Liberty German's phone. Interesting sanction indeed. I think it will be denied. The remedy for any sanction is normally a continuance, which the defense has had to ask for. I don't see Judge Francis C. Gull imposing any sort of sanction against the prosecution in this particular case, well, primarily because she hates the defense attorneys. And I'm not understating that. She hates the defense attorneys. Next, as it relates to motions in limine, the state wants the court to limit what the defense can mention in front of the jurors without prior approval from the judge. There are several pages of items. They include personal attacks on the prosecutors, which I'm going to agree, you shouldn't attack the prosecutors. I mean, you can say, maybe they were delayed, or who was at that meeting, or whose decision was it to delay the production of that evidence. You could answer those questions or ask those questions to the witness, but you should never personally attack the prosecutors in court. Any attempt to introduce evidence of third-party motive that is not relevant or would unfairly prejudice jurors. That goes to the whole issue of the cult, the Odin cult, and other people involved, and could it have been done? But I think that is a defense theory of the case, and prosecutors shouldn't be allowed to ask the court to prevent them from presenting their theory of the case. Like I said, so the prosecutors don't want any mention of Odinism, ritualistic killings, names of others the defense might claim are connected to the killing. That goes to alternate suspect. Normally you have to be able to establish that the alternate suspect was there at the time, could have committed these crimes, and has a pattern of doing those. That would be very tough in this particular situation. Any mention of investigation conducted by former Rushville Police Chief Todd Click, some geofencing information, reference to how discovery was handed over, and the defense asks the court for a hearing to ensure the fair, efficient, and just determination of the facts to be presented to the jury. Now, the state says establishing what is allowed at trial before the trial will clarify the scope of the evidence and avoid long delays during the trial. The defense says approving some of these limitations would violate Allen's constitutional right to present a defense, ladies and gentlemen. Now, you notice the prosecution doesn't want any evidence that would make them look bad, and the defense wants to present evidence that makes the prosecution look bad, and that's a fair shot. But guess what, ladies and gentlemen? Nobody's out for justice, so to speak. The prosecutors are there to win, right? And it's not like they're doing everything above board in this particular case. The defense wants to win, whether Mr. Allen is totally guilty or wrongfully accused. They want to win. That's their goal. And everybody's going to do what they can within the legal limits and boundaries to do so. If you think the prosecution's going to go out there and present all this evidence to make for a fair trial, you, my friend, are hallucinating. The prosecution doesn't present evidence that is good to the defense that would hurt their case of winning. So let's get over that. Each side is trying to win as hard as they can. Now, the defense also says that they expect to present 12 to 24 witnesses to provide relevant and credible information related to third-party perpetrators. We'll see what the judge allows on that. Don't hold your breath, Mr. Allen. I think the judge is going to deny that. And then the motion to dismiss the case. The defense wants the court to dismiss the case, citing the 5th, 6th, and 14th Amendment grounds, the state constitution, and Indiana law as well. The request is based primarily on what it says in the state destroying or losing exculpatory evidence or potentially useful evidence for the defense. Now, we saw this play out in the Alec Baldwin case. If you can really show that the prosecutors are lying, cheating bastards, it may just happen. That's what happened in the Alec Baldwin case, ladies and gentlemen. Now, the defense also cites several times that it believes the state tried to hide information that contradicted its investigators. It also cites what it sees as long, unjustified delays in turning over discovery and possible evidence, particularly in the items that might be favorable to Mr. Allen. Now, remember, that's a lot of the times. Don't expect the judge to dismiss this case, okay? She hates the defense. She's not going to do it. But she should allow some extensive cross-examination on the bumblings of the investigators as well as the prosecutor. That's fair game in my opinion. We'll have to wait and see what the judge says. I think she says denied. The first request to dismiss the case was filed back in February of 2024 on civil grounds, and that was promptly denied on April 2nd without a hearing. The defense says it has learned of other evidence that the state has not turned over to the defense, is missing, or that the state of Indiana has actually destroyed. Well, then you have a Blockburger issue, and that's whether it was destroyed with bad faith in mind or some sort of reckless disregard for destroying that particular evidence. If it was just, pure negligence, which, everything that the police do, if they mess it up, is just negligence. They didn't do it intentionally. But of course, nobody ever gets fired. Nobody ever gets fired in the government, ladies and gentlemen. Anyway, the state obviously says there's no basis to dismiss the case at all. And the state says that the defense motion is replete with unfounded allegations and distorted and misinterpreted facts. It claims it did not destroy or lose evidence purposely in bad faith, because that would be illegal. So of course it wasn't that. The state says that the law is clear. A dismissal of charge due to the state destroying or losing evidence is only permitted when the evidence is materially exculpatory or when the evidence is deemed potentially useful to the defense, and the destruction of the evidence was done in bad faith. That's a Supreme Court case called Blockberger. And the state says the defense is speculating about some of the items that it mentions. Now, of course, the state is saying, yeah, we destroyed some evidence, but it wasn't really material, and it wasn't really favorable to the defense, so bygones be bygones. I brought this up I don't know how many times, ladies and gentlemen. We hear about it in these big cases, and it usually happens in big cases in small jurisdictions because they simply are not prepared to handle the amount of information. They get completely overwhelmed by everything that's coming their way. But then they have to abide by the rules, right? There's no, oh, sorry, we live in a small town exception to the rules of disclosure. It's called the United States Constitution, ladies and gentlemen. The Constitution matters. It's not a little technicality. It's not, oh, it's just a minor violation of the rule. You turn over everything you have. You turn it over as soon as you get it. You don't play games with it. And as my old boss used to say, we're going to give the defense everything they want, and we're still going to convict the defendant. But yet they always play games, ladies and gentlemen. Always. And then they say, well, we didn't really mean to delay it. Okay, we'll see if any clear issue of destruction comes out in these hearings. I don't think it really matters. I expect the judge to deny everything. Mr. Allen will probably go to trial, get convicted, and more than likely be reversed on appeal based upon the conduct of the judge throughout the case. Just my little prediction. All right, next, R. Kelly wants to go to the United States Supreme Court. That's right, you know, the rapper guy that went down for all the bad possession of inappropriate photos of kids and other allegations of sexual assault. Yes, he is asking the United States Supreme Court to throw out his convictions for those possession of those photographs, as well as inducing minors to have sex with him, claiming his alleged acts occurred a decade before the statute of limitations. Therefore, their charges are therefore barred. So here's what he's saying. R. Kelly was accused in 2020 of possessing child pornography and engaging in sexual acts with underage girls way back in the mid to late 1990s. Okay, he's basically admitting it happened. He argued the statute of limitation had already run. Therefore, he should not be prosecuted. Well, the prosecutors argued that a 2003 law called the PROTECT Act made the statute of limitations indefinite for child sex crimes. Well, that's an interesting issue because normally when they change the statute of limitations, it's from that date forward. It's not usually retroactive unless they specifically actually say so. And even then, it's kind of an issue. So like all the stuff now are like, oh, you can come back and sue somebody, for the next year for everything that took place over the last 60 years. I got a real problem with that. Statute of limitations had run, witnesses had died. You really don't allow somebody to have the right to present a defense. But legislatures do it because it makes them feel so good, and they need the votes. And don't get me wrong, all this kind of stuff is horrible. I get it, but you have to come forward with it. You can't wait 60 years and then say, oh, by the way, now I want to prosecute you. It's just not fair. Anyway, so Kelly's attorneys argue that because the conduct for which Kelly now is serving time for under the conduct back in the 1990s, but for the PROTECT Act wasn't passed until 2003, the Act's expanded statute of limitations doesn't apply to the charges against him. And don't get me wrong, I think R. Kelly is a scumbag, but he may be right on this particular one. Anyway, the PROTECT Act extended the statute of limitations indefinitely for crimes committed after the law went into effect in 2003. But Congress specifically didn't include a clause allowing the law to be applied to alleged conduct committed before 2003. You recall, Kelly was convicted of 6 of the 13 counts back in 2020, 3 of the child pornography and 3 of the inducement counts, and he received a 20-year sentence and was ordered to pay hundreds of thousands of dollars in damages to his victims. Now, the Supreme Court will have to decide whether they want to hear Kelly's case on his writ of certiorari. Now, if the Supreme Court thinks there's no issue there or there's no conflict in law amongst the jurisdictions, they can refuse to hear the case. If the Supreme Court decides they want to hear the case, well, guess what? They'll probably grant cert. And they will probably reverse the case because they're granting it since it's been denied up to this point. That's usually the Supreme Court's way of saying, everybody else, you're wrong, okay? And, the Supreme Court doesn't always get it right. They're just the last ones who get to decide. So we'll have to wait and see if the Supreme Court grants a writ of certiorari. Next, Hannah Gutierrez, she would like to go home, and guess what? The prosecutors are opposing it. That's right. The prosecutors are asking the judge to deny a request from the movie armorer that she be released from prison while she is seeking a new trial and her appeal for the conviction of involuntary manslaughter as it relates to the shooting on the set of Rust. Well, the prosecutor, the same one that was involved in the whole Alec Baldwin debacle that looks like she hid evidence, at least that's what the court found, wrote in a response filed late last week that Hannah Gutierrez's motion to release is premature, given that the court has yet to receive completed briefing on the defendant's motion for a new trial, hasn't held a hearing on that yet, and there's been no ruling yet either. So basically the prosecution is saying, Judge, let's just wait and see what happens. Or you could just let her out pending appeal. You could do that too, Judge. Anyway, the lawyers for Gutierrez have argued her case should be reconsidered because the prosecutors failed to share evidence that might have been exculpatory. Exhibit A, prosecutor's testimony, police officer's testimony at the Alec Baldwin hearing held outside the presence of the jury, where the judge found the government withheld evidence and had basically lied about it. I think that ought to cover it. That's just me, all right? Anyway, Gutierrez wants the judge to dismiss her conviction or convene a new trial in the shooting death of cinematographer Helena Hutchins, where obviously Alec Baldwin was the man who pulled the trigger that killed Helena Hutchins. Alec Baldwin's case was dismissed. She was convicted by a jury back in March, and it was overseen by the same judge who threw out the case as it related to Alec Baldwin. I think she'll hopefully do the right thing in this case as well. We'll let you know when it happens. Next, a drunk driver has been charged with murder. The alleged drunk driver, accused of crashing into a Long Island nail salon and killing 4 people, including a New York Police Department police officer, last month has been charged. Stephen Schwally, who prosecutors previously said downed 18 beers before the hit and run, the hit the building and stop, will be arraigned Thursday in Riverhead, New York. Now, Schwally is accused of crashing his car into the Hawaii Nail and Spa in Deer Park on June 28th while drunk and killing 4 people, including an off-duty police officer, like I said. Schwally was indicted by the grand jury, which has 4 counts of second-degree murder. He had a court appearance earlier this month, and Schwally was ordered held on a $1 million bond from the deadly crash. Now, the defendant's vehicle went through the intersection, went airborne, struck the curb in front of the nail salon, navigated through one empty parking spot, and slammed through the nail spa's front window. The defendant admitted to the police detectives that he had consumed, only 18 beers the night before and indicated that he stopped drinking about 3 or 4 a.m. So obviously it's okay. Anyway, Schwally, who is unemployed, is living in transient hotels. He's apparently a veteran of the United States Marine Corps. He retired from a job at UPS, according to his lawyer, when he was making a bond argument. Now, Mr. Schwally is not his first time drunk driving. Had an incident back in 2013 when he slammed into a mailbox and then arrested as he left that scene and was found behind the wheel asleep when the police arrived. I don't know. I just don't know. I think anything drunk driving is one of the most preventable crimes ever. It's so simple to avoid. Just take an Uber. Nothing against, having alcohol. Just do it where you're not going to drive. It's that simple, ladies and gentlemen. And if you do screw it up like that, yes, guess what? You're probably going to prison. this guy's going to prison. If he's convicted, of course, because we'll give him that presumption of innocence. Next, I don't even know what to say about this. Is this true love? Is this a publicity stunt? I don't know. I mean, it's being reported about. I'm talking about it. But here's this real estate agent, Laura Gerke. Now, she met her future husband, a guy by the name of Joshua Stewart, on a dating app called writeaprisoner.com. I don't know. Maybe we need to get them as a sponsor. I don't know. Anyway, they met on this dating app back in December of last year because Ms. Gerke was feeling lonely. Yes, she was feeling lonely. Anyway, now you may think, do I know this woman? I've never heard of her, but apparently she was in a Netflix show called Too Hot to Handle, Germany edition. Anyway, apparently Ms. Gerke was traveling home for Christmas, but there was an issue, so she was forced to spend the Christmas season alone in Dubai. But after scrolling through some TikToks, Ms. Gerke stumbled upon a video about writing a prisoner online and decided to wish an inmate Merry Christmas. How sweet. The Christmas season cheer. Anyway, one particular profile caught Ms. Gerke's eye, and she began exchanging messages with Joshua Stewart. Now, the pair were soon speaking on the phone up to 11 hours a day, and it wasn't long before Joshua popped the question after 6 weeks of knowing one another. Now, Ms. Gerke then flew to Washington to marry her criminal beau in June during a 90-minute prison ceremony. How romantic. I wonder where they registered. Who knows? So despite having a conviction for distribution of a controlled substance resulting in death, so he's a drug dealer that wound up killing people because of his poison that he was distributing, Ms. Gerke said that she never judged her hubby over the reasons of his incarceration. Anyway, Gerke said, I was sitting here home alone, feeling very sad because I couldn't be with my family due to some visa issue. Like I said, had to spend her time in Dubai. So she saw a video and decided to get on writeaprisoner.com and wish him a happy birthday. I thought if I could just send one message saying Merry Christmas, wouldn't it make the world a whole better place? So she went to the website and she saw her now husband's account, and he was the second person I clicked on, and I saw on his profile, he said he liked poetry. And he was really interested in poetry. Like, I wonder if he has a poetry for the tattoo directly between his eyes of a knife. I don't know. Anyway, after exchanging messages about his poetry, Laura, Ms. Gerke, and Joshua began speaking on the phone for as long as 11 hours a day. And they just really clicked, you know. They really, really clicked, and it was really emotional, and it was really intelligent. And she didn't really go into the whole crime because, you know, why do you really need to get into those details like that? She was hearing a lot of stories about him growing up, and before I knew the details about why he was incarcerated, I maybe saw things just a little bit differently. Because she knew the backstory, it didn't change her opinion of him at all. Anyway, back in February, Joshua popped the question to Ms. Gerke during one phone call, and the couple wed 4 months later in a prison ceremony. Obviously, they were unable to consummate the wedding, but they're trying to get that conjugal visit here in the next year. Now, Ms. Gerke flew over to the United States at least 12 to 13 times, and they got married on the 13th visit. It was a prison marriage, and he was allowed to have a best man, the groom was, and they had their own color theme, white. And she felt it was just super right. And their families are supportive, so they got all that going for them as well. And, you know, you just wish them the best, don't you? Anyway, Laura's hoping to live in the United States with her husband when he gets released, which could be sometime as early as December of 2025. Like I said, ladies and gentlemen, I just don't know. Go to start an app for prisoners to date. Wow. I just don't know. I mean, I get wrong. People need people. People need relationships. I get that. But to marry him, he's not even going to be able to come to Germany where she resides because he has a felony conviction for drug distribution. She'll have to come here. I wonder if she's going to move here and maybe start her own real estate business here. Interesting. We'll have to wait and see how that goes. I don't know. Maybe I'm just being too harsh, too sarcastic. I don't know. I'm going to bet it doesn't last. I bet it doesn't last. These prison romances never last. maybe I'm wrong. Let me know if you think I'm wrong. Just a true love story, or maybe I'm just being a little too cynical. Next, could this only happen in Florida? Probably not, but it seems like it happens in Florida for sure. Anyway, some sheriff deputies in Florida responded to a report of a road rage incident that resulted in a fight with a suspect who had thrown $15,000 in cash out of the window. Now, the sheriff's deputies responded about 6:30 p.m. Saturday about this road rage incident, and when the deputy arrived, he saw a man, later identified as Jose Hernandez, throwing garbage out of his car. The deputy, obviously curious as to what's going on, walked up to the car, and he saw a young child naked, covered in feces, and unbuckled in the front seat. Now, this is all according to the affidavit for probable cause for arrest. According to the same affidavit, there were also 2 pit bulls in the back seat, one of which seemed very aggressive to the police officer. The police officer, deputy, asked Hernandez to get out of the vehicle several times, but he would not do so. And after the deputy was doing this, Mr. Hernandez dropped a $100 bill out of his pocket and claimed that wasn't his. I would have claimed it. Anyway, after the 7th time requesting to speak to him behind the car, the man in the car rolled the back driver's side window down, and his pit bull climbed halfway out the window. And the deputy wrote that the driver said, "Are you a pussy? Are you scared of my dogs?" Anyway, Hernandez allegedly told the deputy that he just fought one like you and got out of his car as if he were going to fight. The deputy got Hernandez to the ground, but the suspect kept resisting commands as cars on the road were continuing to go by. As they were tussling on the ground, Hernandez got up, allegedly said, "Are you ready to get run over?" The deputy twice used his taser on Hernandez. The second time, Hernandez fell, but quickly got up and ripped off the probes from his body and ran away. All according to the affidavit of arrest warrant, ladies and gentlemen. Mr. Hernandez also allegedly told his dogs to attack the deputy. By the time the backup deputies arrived to subdue Mr. Hernandez, they had already used a spray to get the dogs away from them, and the deputies searched around the car and discovered that Mr. Hernandez was not throwing out trash, but he was throwing out cash. They recovered more than $15,000 in cash, and cops also found a bag containing about 8.5 grams of fentanyl, along with a baggie to distribute the drug, according to the arrest affidavit. Well, now Mr. Hernandez is facing charges of battery of an officer, resisting arrest, neglecting a child without bodily harm, trafficking in fentanyl of 4 grams or more, and possession of drug paraphernalia. He was also taken to the hospital because of his injuries, because when he fell, boo-hoo, from removing the probes from him, from the taser. So then he went to jail. And guess what? Mr. Hernandez wasn't telling how he knows the child that was in the car. Now, I think the one mistake that the police officer made in this particular case with Mr. Hernandez was using his taser instead of his gun. Big mistake. Big mistake. Should have gone directly to the gun. But that's just me. Next, our dumb criminal of the day. Do you remember back in the day where people were stopped and they had drugs on their person and they said, "Oh, those aren't my pants. I didn't know those were there." Well, our today dumb criminal is bringing that back, but with food, ladies and gentlemen. You know, with food, it had to be dumb criminal, right? So a nurse aide responsible for distributing medicine to inmates at an Indiana prison has been charged with trying to smuggle cocaine and marijuana into the facility in a bowl of frozen lasagna. That's right, lasagna, ladies and gentlemen. According to court records, Regina Davis arrived to work earlier this month at the Indiana State Prison, where the property of the employees, like everybody else, has to go through the x-ray machine before they can enter the facility. It's a maximum security facility, so that even seems to make more sense. Well, there's roughly 2,000 adult male prisoners in this particular location, and it's about 45 miles east of Chicago, Illinois. As Miss Davis's lasagna moved through the x-ray machine, though, the other officer thought that something looked a little odd. So the fellow colleague said, "Let's take another look at this." And when they examined the food, they found several packages wrapped in electrical tape that contained cocaine and pot. You can't make this up, ladies and gentlemen. During questioning, Davis claimed that she had been at a female friend's house prior this evening getting a tattoo when the woman gave her 2 containers of lasagna to eat. Davis claims not knowing that the food was stuffed. It's also unclear if the lasagna also contained tiny meatballs. You just don't know about these kind of things, ladies and gentlemen. And of course, Miss Davis did not give the name of her friend who was the cook either. Anyway, Miss Davis reportedly agreed to allow her phone to be searched. Investigators found photos wrapped of the drug packages that were taken a day earlier. Her story then changed. Ms. Davis claimed that she had been getting calls from unknown numbers from unknown individuals who threatened her safety, and her brother, who said he had been released from prison, who was in a work release program in South Bend, Indiana. Davis said that she had been instructed to go with a black guy to pick up the drugs, some of which she admitted wrapping herself. The narcotics, she added, would be picked up in the prison by an individual who stopped by the drug room where she works. The courier would say, "We're there to pick up some cream for their feet." Despite her somewhat compelling explanation and the duress that she may have been under, Miss Davis has been arrested for 2 felony narcotics charges. She's free on a $1,500 bond. She is pled not guilty and has been ordered by a judge to appear in court on August 2nd for a status hearing. There you go, ladies and gentlemen. You can't make this stuff up. There's probably some truth to it. My guess is it's probably something in between, maybe like a romantic relationship in the prison, I'm sure. Where have we seen that before? Seen it many times. Seen it in real life, ladies and gentlemen. I don't know what it is about healthcare workers and inmates. They always seem to come together. Anyway, that's all we have for you today. Remember, please join us tonight, 6 p.m. Mountain Time, live. We're going to do our regular show, Tuesday night live, and then we'll do our Patreon show as well. So thanks for watching. We'll see you next time. Remember, the Constitution matters.